Welcome to JMW's Inside Man YouTube channel. So we found out over the festive period that Sir Jim Ratcliffe has acquired some shares in Manchester United. Dan Gianferrari is a senior associate solicitor within JMW's corporate department, and Dan joins me now. So Dan, is it sensible to have a minority shareholding, a 25% shareholding in a business?
Well, I suppose it depends on the motivations behind people, behind why they want to be involved. We do see it. On the face of it, just holding 25% of the same class of shares as the majority shareholder, that's not going to get you a great deal. That would be subject to the company's share rights that are baked into the company's articles and Companies Act. So the influence he would have would be fairly limited. So we don't tend to see that situation on its own. It's almost certainly going to come with a very detailed shareholder agreement that's going to set out the real detail of what these people are going to agree between themselves, of what their relationship is in relation to the shares in this company and how they agree to run the company. So that's where the real detail will be set out. Articles on their own, they're a matter of public record. It will set out the share rights, but the real stuff is going to be in this shareholder agreement, I would have thought.
And 25%, it sounds like a foot in the door for me. Does it then open up the door to acquiring more shares in the future?
I think it can do. I think it probably will do. I don't think he's got what's called an option to acquire the further shares from the Glazers. But one of the big principles that we would see in a shareholder agreement would be a sort of control on how shares are transferred. So without the shareholder agreement, the shares could be transferred however the Glazers wanted. So Jim could end up with some other American owners as his business partner. So routinely, shareholder agreement says no, we're not going to do that. We're going to control how shares are transferred. So what I think will be in there is, and in fact that statement to the SEC probably confirmed it, that there will be what's called preemption rights in there. So right of first refusal. So if any shareholder wanted to sell their shares, then the other shareholders got sort of first dibs on buying them. There'll probably be what are called drag along and tag along rights in that, so that if in a few years' time someone swooped in and wanted to buy all of the shares in Manchester United PLC, then the Glazers, being the majority shareholders, would be able to accept that offer because they would have the ability to drag Sir Jim's shares along with them. So the net effect of that is that there could be a sale of all of the shares in Manchester United PLC. I suspect Jim would be able to match any offer at that point and acquire them himself. So with the preemption rights and the drag along, we could see a situation where the Glazers are fed up. Jim could get them all.
And Dan, I've worked alongside you for long enough now to know that when businesses are acquired, there are usually sort of certain promises that of what to expect. How does that differ then, given that the other shareholders are still going to be in the business? We know the Glazer family, still going to have a lot of shares.
Well, that's where your shareholder agreement comes in again, Dom. That we're going to have, and it's one of, again, an important and regular part of any shareholder agreement. We're going to have a list of reserved matters, and that's going to be essentially, we can't do these things. We'll agree not to do these things without getting consent from Sir Jim, and that will be a pretty long list in this case, I think. And they may also have deadlock provisions. So if they really can't agree, there's a mechanism for sorting a decision out. I mean, it could end up with a nuclear option where one buys the other out. Of course, that's a possibility in a deadlock provision. But the shareholder agreement is going to help keep them honest. So there'll be enough reserved matters in there that they know how to make these decisions, and I think the other big feature of this is that it appears Sir Jim has control over the footballing activity. So I think we don't quite know how that's going to work, but that seems to be, again, it will be in the agreement where that aspect of it is delegated to perhaps call it a subcommittee of the board, and Sir Jim, as the minority shareholder, is going to have control over those activities. So, yeah, the more certainty you can have, the better, and that's what these agreements are looking for. Well, any agreement, as you know, Dom, it is about getting some legal certainty into a situation.
And Dan, I know that you and the team do have a lot of expertise at buying and selling sports clubs, but not everybody will want to buy 25% in a Premier League football club. So more generally, how can you and the corporate team at JMW Solicitors help?
Well, we do transactions of any business, disposals, acquisitions, share purchases, share sales, asset purchases, asset sales. So it really doesn't matter what the business is. It doesn't really matter the value of the transaction. As I say, we're probably not going to get a 1.3 billion one on our books. I'm sure our insurance wouldn't cope with that. But we do anything from, £50,000 to a few million. The level of the price being paid doesn't really matter. The principles are the same, whatever kind of transaction you're doing. We're going to need you're going to need some help, and we can do that.
Dan, thank you very much for your insight. If you'd like to contact Dan and the corporate team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.